conference will begin shortly. Please kindly find your seats. Thank you for coming to the Conference on International Advocacy to ensure accountability for North Korea's human rights violations. My name is Hae Nam, and I'm the Manager of International Affairs at NK Watch. Thank you so much for your valuable time today and your decision to participate in the conference. First, we will hear the opening remarks from Her Excellency Joan Donnerwald. She is the Dutch Ambassador to South Korea. Her interests mainly lie in climate change and gender equality. Prior to moving to Seoul, she served 4 years as the Dutch Ambassador to Sri Lanka, also covering to Maldives. She was appointed as the Netherlands Ambassador to South Korea in August 2019. Please welcome the Ambassador with a round of applause.
안녕하세요. Good afternoon. Good morning in Europe. I would like to welcome you all to this international conference on accountability for human rights violations in the DPRK. Let me begin by expressing my deep appreciations for our hosts, NK Watch, for all the excellent work they have been doing to defend human rights in the DPRK. It's truly impressive what you have managed to achieve as a small organization. You've already done so much valuable work in documenting and recording, by collecting information, and by sending petitions to the Special Rapporteur and the Human Rights Council. It's especially important that you have been able to give a voice to the victims of human rights violations, victims that otherwise may have not been heard, but who have the right to accountability and justice. Ladies and gentlemen, today we will be speaking about legal avenues for creating accountability for human rights violations in the DPRK, for meaningful and practical strategies to overcome barriers to justice and redress. I'm looking forward to hear from all the experts that are here today, or who have called in from the other side of the world. This illustrates that even though right now we are next door to North Korea, this is not a local issue. It's a global problem that requires a multinational approach, from evidence gathering to prosecution to redress for victims. Accountability for serious human rights remains a significant challenge from which the international community cannot shy away. If the international community does not keep doing its utmost to hold those responsible for human rights violations accountable for their acts, the international rule of law is not being upheld, and that will affect all of us. That is also why the Netherlands is proud to support this important initiative, and why accountability for human rights violations is an important priority for the Netherlands. We strongly believe that pushing for justice promotes a shared sense of hope, commitment, and duty. We are a proud host state to international courts and tribunals, including the International Criminal Court, and we have a long tradition of supporting efforts to fight impunity. We remain committed to upholding the rules-based international order, with the victims at the heart of our strong pursuit for accountability and justice. I hope you will have a fruitful conference, and I'm here looking forward to the discussions. Kamsahamnida, thank you very much.
Thank you, Your Excellency. We also appreciate your strong emphasis that North Korean human rights are not a local issue, but an international one. Next, the Executive Director of NK Watch, Myung-chul An, will deliver the welcome address. Mr. An has continuously addressed North Korean human rights issues for the international community since he defected from North Korea. And since 2013, he has been working as the executive director of NKWatch. Please welcome Mr. An.
네, 안녕하세요. NKWatch 대표 안민철입니다. 저는 오늘 이 컨퍼런스를 개최할 수 있게 도와주신 요한난 도노바르트 주한 네덜란드 대사님과 네덜란드 정부 관계자분들께 먼저 감사를 표하고 싶습니다. 네덜란드 정부는 북한 인권 문제 해결을 위해 지속적인 관심과 지원을 하고 있습니다. 그리고 작년부터 저희 NKWatch의 조언자이자 협력자로서 지원을 주고 계시는 제프리 나이스 경과 리베카 트럼프 대표님 그리고 변호사님들에게 감사하다는 말씀을 드립니다. 그리고 강한 의지와 용기를 내어 이 자리에 참석해 주신 책임 규명을 위한 북한인권 증언자 연대 대표로 오신 북한인권 피해자분들께 깊이 감사의 말씀을 드립니다. 오늘 이 자리에 귀중한 시간을 내어주신 존경하는 마이클 커비 전 UN COI 위원장님께도 감사의 말씀을 드립니다. 또한 NKWatch에 항상 연대와 지지를 보내주고 계시는 이메시 푸카렐 유엔인권 최고대표 서울사무소 소장대행님과 에릭 히스케스 인권관님, 독일의 북한 인권재단 사람의 니콜라이 스프레겔스 대표님에게도 감사를 드리고 싶습니다. NKWatch 파트너이자 친구인 스프레겔스 대표님은 오늘 이 자리를 위해서 베를린에서 서울까지 와주셨고 대표님의 헌신에 각별히 감사드립니다. 그리고 오늘 이 컨퍼런스 홀까지 와주시고 그리고 온라인으로 참석해 주신 각국의 외교관님들, 국내외 NGO 관계자분들, 전문가분들 모든 분들께 감사와 존경을 표하고 싶습니다. 이 컨퍼런스는 제프리 나이스 재단이 NKWatch가 제공한 북한인권 피해 자료들을 바탕으로 검토, 분석한 북한인권 침해에 대한 법적 대응 방안 보고서에 대해 국제사회와 공유하고 함께 논의하기 위한 자리입니다. 이 연구는 제프리 나이스 경의 책임하에 이루어졌습니다. 제프리 나이스 경께서는 NKWatch에 항상 깊고 넓은 지성과 지혜를 제공해주고 있고 이 컨퍼런스 개최에도 많은 도움을 주셨습니다. 이 자리를 통해 감사의 말씀을 드립니다. 또한 NKWatch의 친한 파트너인 리베카 트럼프 제프리 나이스 재단 대표님은 오늘 이 컨퍼런스를 위해 헤이그에서 서울까지 와주셨고 이 연구의 공동 집필자로 활약해 주셨습니다. 트럼프 박사님의 헌신에 찬사를 보냅니다. 또한 이 보고서를 공동 집필한 제프리 나이스 재단의 루이 피코, 아담 스미스, 네이션 풀러, 홀리 암스트롱 변호사님들의 헌신에 깊은 존경과 감사의 말씀을 드립니다. 국제사회와 여기 앉아 계신 모든 분들의 노력으로 북한 인권 상황에 유의미하고 일부 긍정적인 변화가 있었습니다. 예를 들어 북한 외무성은 국제사회의 인권 압박에 대한 대응을 위한 TF를 2000년대 중반부터 가동시켜 왔습니다. 그리고 보안원과 보위원들의 수감자 대상 구타와 고문은 눈에 띄게 감소했습니다. 물론 이것은 북한 인권 상황이 근본적이고 구조적인 변화가 이루어졌다는 것을 의미하지는 않습니다. 북한 인권 문제의 근본적 해결을 위해서는 아직도 많은 노력과 시간이 필요합니다. NKWatch는 시민사회단체 차원에서 그 해결 방안을 찾는데 실질적인 기여를 하고 싶습니다. 그래서 저는 NGO의 대표이자 탈북민의 한 사람으로서 모든 참석자분들에게 간곡히 부탁드리고자 합니다. 국제사회에서 북한 인권에 대한 관심이 약해지지 않도록 지속적으로 이슈를 제기해 주시기 바랍니다. 그리고 북한의 반인도적 책임 규명이 현실화될 수 있도록 조력자이자 파트너가 되어 주시기를 간곡히 부탁드립니다. 감사합니다.
Thank you, Mr. An, for your considerate remarks. For interpretation, we ask that all speakers talk slowly and clearly. Thank you for your understanding. Now, we will hear from Imesh Pokharel, the representative ad interim of UN Office of the High Commissioner for Human Rights in Seoul. Mr. Pokharel's areas of expertise include rule of law, accountability, human rights mainstreaming, and peace building. He has worked with the OHCHR since 2006 as a regional emergency coordinator and as a human rights officer in Asian countries. Please give a warm welcome to Mr. Pokarel.
Annyeonghaseyo, everyone. I would like to thank the NK Watch for organizing this event, exploring avenues to deal with human rights abuses in the DPRK. I'd also like to thank the Geoffrey Foundation, SARAM, and the Netherlands Embassy in Seoul for collaborating on this important initiative. Victims and their families' quest for truth, justice, and accountability for human rights violation in DPRK continues to date. While there has been several efforts for victims, civil society organizations, the United Nations, and the member states to seek accountability, the lack of cooperation from the DPRK and the isolation of the country has made it hard to see any tangible results. This is a harsh reality. However, given the difficulty in addressing impunity in several countries, the international community is now increasingly acknowledging the need for exploring creative accountability and justice opportunities in situations like the DPRK. The International Criminal Code remains the key architecture for legal accountability for serious human rights violations. However, many countries where we are witnessing serious human rights situations like in the DPRK are not a party to the ICC. Time and again, we have also witnessed that referral of the situations to the ICC by the Security Council has not been that easy for various reasons, including political considerations. It is in this context that the international community, including the United Nations, has been exploring ways to push the accountability agenda. In recent years, investigative mechanisms mandated to collect and preserve evidence for accountability purposes has been established, such as in Myanmar, Syria, and Sudan. These mechanisms are important for preparing the groundwork for any future accountability mechanisms. They undertake important work such as continued documentation, legal analysis of cases, and engaging with different member states and stakeholders to pursue accountability under accepted principles of universal or extraterritorial jurisdictions. These mechanisms are also important avenues for the victims to connect with the international community to pursue justice and accountability. In the DPRK, as mandated by the Human Rights Council in 2017, OHCHR has been strengthening its monitoring and documentation efforts and has established a central information and evidence repository. Its legal experts have been assessing all information and testimonies with a view to developing possible strategies to be used in future accountability processes. It is also undertaking consultations with different stakeholders, including victims and families and people from the DPRK, to develop possible accountability strategies. Civil society organizations are key partners for the office in pursuing accountability in the DPRK. Civil society organizations can help the office by sharing information and evidence, helping us to reach out to the victims and families, engaging with the office for developing strategies, undertaking research, and through advocacy with member states and other stakeholders. Last year, NK was provided 768 petitions, which it had submitted to the UN special procedures to be included in the OHCHR Evidence and Information Repository. This was an important contribution to strengthening our repository and analysis. While we are all seeking to pursue accountability, victims and their families should be at the core of all these initiatives. As the UN High Commissioner for Human Rights has recently stated, it is essential to empower victims and survivors to contribute to, shape, and participate in any accountability processes that affect them. Due acknowledgement of their experiences, their rights, and the legitimacy and importance of their voices contributes to restore victims' dignity. All investigative bodies need to speak to survivors and their communities and listen, understand, and internalize their needs and concerns. This is an essential precondition for the successful pursuit of justice and truth and can open the door to much broader reconciliation. It is equally important that all elements of accountability, such as criminal justice, reparations, truth-seeking, institutional reforms, and guarantees of non-repetitions are explored. Pursuing accountability in the DPRK can be hard, but not impossible. Let us all make accountability central to our advocacy in the DPRK. I hope that today's discussions will explore fruitful discussions, and I look forward to listening from all of you. Thank you very much.
Thank you, Mr. Pokarel. We appreciate your practical advice and encouraging for the victims, organizations, and activists who are working for holding North Korea accountable. Thank you. Next, Sir Geoffrey Nice will deliver a keynote speech. He's participating in the conference online. He is one of the most renowned human rights lawyers and a co-founder of the Geoffrey Nice Foundation. He is now the chairperson of the Uyghur Tribunal. In 1998, he was recruited to the International Criminal Tribunal for the former Yugoslavia. He was the lead prosecutor for Slobodan Milosevic. He insisted on an official UN Commission of Inquiry on North Korea's human rights violations. Following the establishment of the COI in 2013, he served as an advisor to the Commission. Please welcome our keynote speaker, Sir Geoffrey Nice.
Good morning. I only have 2 minutes, so 1 minute, I think, so I shall have to be brief. First of all, it's important to recognize that those of us from overseas do not share your language. Oh, by the way, can those of you who can turn on your cameras, please? It's not much fun speaking to a screen of black squares. Please turn on your cameras. We come from a different country, different language, different culture, and it's quite wrong of us to make any assumptions about your culture and your politics and everything else. And so we have to be very cautious about cultural difference and completely respectful of it. Thank you very much, Yoon Hae Kim. Let's see if Lizzie Han, Yi Won Yang are better. Come on, more faces, that's nice. Nice to talk to people. So I'm going to make 1 point about culture and 1 point only, I think. And it's this. There's a very good conference booklet, pre-reading. In the United Kingdom, if you provided pre-reading to a group such as you, most people will not have read 1 word of it. In your culture, I suspect you will all have read every word of it, so I'm not going to bother to say anything that's in my speech. There's one thing in my speech that needs correction, and that is the implication that everyone in the foundation has worked pro bono. That's not the case. NK Watch provided fees for the 4 researchers. The rest of the work is done unpaid. And unpaid work is something very important for everyone to understand. And it explains why I and Lena Trump, and under that the researchers, will not want 1 more word of thanks from anyone. Why? Because we don't need thanks and we don't want thanks. Why? I think this is very important for people representing suffering groups to understand. There is, around the world, it's not just in England, it's around the world, there is a reservoir of work, unpaid work, that can be used, and maybe the North Korean dilemma, tragedy, needs to get as much as it can from that resource. But when people work unpaid, it is not for thanks because they don't need thanks. It is simply because they prefer to do what they may be able to do, for example, for North Korea, to doing their gardens or going on holiday. They just prefer to do it. But here's the important point, I think. Probably they prefer to do it because there is an understanding in the dangerous world in which we live that we owe duties. The 1948 Declaration of Universal Human Rights identified rights, universal rights. But every right has a corresponding duty. Your right is my duty. My right is your duty wherever you may live. And increasingly, people, I hope and believe, recognize that they owe duties to those who suffer anywhere around the world. For example, when I used to go to the meetings in Westminster of the parliamentarians, who are of course paid, but the meetings were open to the public concerning North Korea, the majority of people there had no interest, apart from no personal interest, apart from doing what they could for North Korea, if they could do anything at all. And I believe, and I hope I'm right, I repeat, that this reflects an understanding of the universal duties each citizen owes to each other. Why do I mention that? For this reason: if such a resource, the resource of unpaid work, can be useful to the North Korean tragedy, and I believe it can, it is very important that what is presented as benefiting from their help, as needing their help, is coherent. That is why in my printed speech, which you will all have read, I suggest it is critical not just that a record is made. That is absolutely critical, because a record of events allows for accountability, which is also critical in whatever form and whenever it comes. But if the outside world can see a coherent, a shared endeavor by all those working for the problem, then they are far, far more likely to offer their assistance. And their assistance may be required, I think, now, as North Korea is falling down the list of fashionable causes to support. Their assistance, the assistance of the great number of people who will prefer to work for the North Korean problem to going on holiday, to doing their gardens, then if it's coherent, a shared, single, clear objective, then their resource may be available to you. That's all from me. The rest, and I've gone on far too long, the rest of what I might have said is in the speech, but you've already read that. But the 3 more people who've joined, please turn on your cameras.
Okay, thank you, Sir Geoffrey, for your sincere advice. For session 1, Dr. Nevenka Trump will lead the conference as the chairperson. Dr. Nevenka Trump is the executive director and co-founder of the Geoffrey Nice Foundation. From 2000 to 2012, she worked in the Office of the Prosecutor at the International Criminal Tribunal for the former Yugoslavia, where she was the principal researcher on history and politics in the trial of Slobodan Milosevic. She has been working for the victims of Srebrenica's family in Bosnia and Herzegovina. Also, she has been working in the Department of European Studies at the University of Amsterdam since 1992. Since travel all the way from the Netherlands to host today's conference, please give a round of applause for the Dr. Nevenka Trump.
Thank you very much. And thank you for introductory words. I don't think I should spend any time talking about myself. Ladies and gentlemen, welcome. I am opening now the working part of this conference, and the working part of the conference will consist of 2 sessions. Session 1 is supposed to last half an hour, and I will observe this time because we have several distinguished speakers who will address us. And the first talk will be by Kwan Young Lee. Dr. Lee is Program Director of NK Watch, and his address on NK Watch's human rights advocacy activities and cooperation with the international community will last 10 minutes. Dr. Lee, please, the floor is yours.
네, 감사합니다. 네, 안녕하세요. 방금 소개받은 NK워치에서 근무하고 있는 이관형입니다. 오늘 모두들 다 귀중한 시간 내주셔서 너무 감사합니다. 그리고 특히 이 컨퍼런스 좌장으로 저기 활동을 해주신 네벤카 트럼프 박사님께도 깊은 감사의 말씀을 드립니다. 실은 제 다음의 발표와 토론을 해주실 분들이 오늘 컨퍼런스의 핵심 주제들을 말씀을 해주시기 때문에 저는 시간을 조금만 쓰도록 하겠습니다. 이 자료집에 나와 있는 내용보다 제 발표를 조금 더 축약을 해서 말씀을 드리도록 하겠습니다. 다 보이다시피 제가 오늘 발표할 주제는 NK워치의 인권 옹호 활동과 국제사회의 협력입니다. NK워치는 누구이고 무엇을 하고 있고 또 앞으로 우리의 도전 과제는 무엇인지에 대해서 간략하게 말씀을 드리고자 합니다. NK워치는 피해자들을 위한, 피해자들에 의한, 피해자들의 시민사회 단체입니다. NK워치는 지난 2003년 6월 북한 정치범 수용소 피해자와 그의 가족들이 함께 설립한 비영리 민간단체입니다. 저희 법인의 설립 목적은 북한 내 정치범 수용소 철폐, 그리고 북한 내 인권, 자유, 민주주의가 확산을 시키는 것입니다. 저희 NK 구성원들은 탈북민들과 그리고 한국에서 북한 정치 그리고 국제관계를 전공한 연구자들로 구성된 전문가 그룹이기도 합니다. 여러분들이 다들 잘 알고 계시겠지만 NK워치는 정말 작은 조직입니다. 하지만 그에 비해서 많은 일들을 수행하고 있습니다. 그중 하나가 바로 북한 인권 피해 조사와 기록입니다. NK워치는 NK워치 구성원 모두 각각 탈북민 네트워크를 다 보유를 하고 있는데요. 실은 다들 잘 아시겠지만 북한 인권 피해 조사와 기록을 위해서는 탈북민 증언이 핵심입니다. 그래서 NK워치는 저희들이 각각 보유하고 있는 탈북민 네트워크들을 이용을 해서 탈북민들에게 접근을 하고 그리고 인터뷰를 진행을 하고 있습니다. 그리고 이 증언자들의 동의를 받아서 유엔에 청원서를 제출을 해왔습니다. 이 청원서에는 매우 상세한 인권 피해 기록이 담겨 있는데요. 저희는 이 작업을 2013년부터 현재 올해 6월 30일까지 총 828건의 청원서들을 유엔에 제출을 해왔습니다. 그리고 매년 1년마다 이 청원서들을 묶어서 자료집으로 발간을 하고 있습니다. 네, NK워치 활동은 저희 북한 인권 피해 조사와 기록에만 그치지가 않습니다. 북한 인권 상황을 계속 주시하고 분석하고 있고요. 그리고 관련 보고서들을 발표를 합니다. 그리고 정치범 수용소의 변화 여부를 지속적으로 관찰을 해서 국내외 그리고 공개 혹은 비공개적으로 브리핑과 정보를 제공하고 있습니다. 네, 다음은 책임 규명과 관련된 활동입니다. NK워치는 북한의 반인도적 범죄 책임 규명을 위해서 향후 증언자로 활동을 해주실 탈북민들과 함께 책임 규명을 위한 북한 인권 증언자 연대를 설립했습니다. 즉, 북한 인권 피해자들은 더 이상 침묵하지 않고 책임 규명을 위해서 자신의 목소리와 권리를 찾기로 했습니다. 그리고 이분들을 대표해서 오늘 이 컨퍼런스에 몇몇 분들이 참석을 해주셨습니다. 좌장을 맡고 계신 네벤카 트럼프 박사님께 좀 양해를 부탁을 드리고 싶은데 이 증언자 세 분이 오늘 컨퍼런스에 오셨는데 제가 이 자리에 좀 한 분씩 소개를 해도 되겠습니까? 네, 감사합니다. 네, 먼저 박금옥 선생님 한번 좀 감사합니다. 뒤를 잠깐 한번 마스크 쓰시고요. 네, 박금옥 선생님은 한경남도 단천시에 소재한 21호 정치범 수용소에서 태어나셨습니다. 실은 이분은 정치범 수용소에서 태어나신 게 특이한 이력이시죠. 만 1세가 되기 전에 18호 수용소로 옮겨졌고요. 그리고 2000년대 중반에 무사하게 18호 수용소에서 나올 수 있게 되었습니다. 이 박근복 소장님은 실은 18호 안과 밖에서 말로 형언할 수 없는 인권 피해를 당하셨습니다. 그래서 그렇지만 다행히도 2010년도에 무사히 탈북을 하셨고요. 현재는 두 아이의 엄마이자 그리고 아내로서 평범한 삶을 잘 살고 계십니다. 다음은 김동남 선생님. 잠깐 자리에서 감사합니다. 김동남 선생님의 아드님은 현재 북한에서 강제 실종 상태입니다. 2006년 김동남 선생님의 아드님이 중국에서 기독교 성교사를 접했다는 이유로 2008년도에 함경북도 회령시 보위부에 의해서 체포가 되었고요. 이후 강제 실종 상태입니다. 김동남 선생님은 2009년도에 한 북한에 있는 친척을 통해서 아드님이 완전 통제 구역으로 분류되는 함경북도 화성군 소재 16호 정치범 수용소에 구금되었다는 사실을 접하게 되었습니다. 북한 당국은 현재까지 김동남 선생님 아드님의 행방, 생사에 대해서 확인해 주고 있지 않습니다. 현재 김동남 선생님은 한국에서 직장 생활하고 계시고요. 오늘 와주셔서 감사합니다, 선생님. 그리고 다음은 박광일 선생님이십니다. 네. 이분은 학교에서 교사를 하셨습니다. 교사를 하셨는데요. 박광일 선생님은 한국 드라마를 유포했다는 이유로 1998년 함경북도 보위부에 체포되어서 고문을 당하셨습니다. 고문 결과 영구적인 신체 장애를 입게 되셨는데요. 치아 5개가 영구히 손실되었습니다. 그리고 현재까지 만성 골수성 백혈병을 앓고 계시고요. 고막 손상도 매우 심해서 현재 청력이 매우 떨어져 있는 상태입니다. 그리고 유엔 고문방지위원회 다들 잘 알고 계시죠? 이쪽으로부터 지원을 받아서 한국의 한 대학병원에서 한 PTSD 치료만 3년간 받으셨습니다. 박광일 선생님은 현재 북한 인권 옹호 활동 관련된 시민사회 단체를 운영하시는 대표이시기도 하시고요. 그리고 목회자로 활동을 하고 계십니다. 실은 오늘 주인공은 이 세 분이 주인공이라도 할 수 있을 것 같습니다. 그래서 이 세 분 한번 자리에서 일어나 주시면 한번 응원의 박수 부탁드려도 되겠습니까? 한번 일어나 주십시오. 네, 감사합니다. 그럼 계속해서 제 이야기를 이어가겠습니다. 저희 NK워치가 앞으로 해야 될 도전까지는 책임규명을 위해서 이런 증언자분들을 더 규합을 하고 연대를 강화하는 것입니다. 그리고 무엇보다 책임규명을 위해서 실제로 도움을 주실 변호사분들 그리고 국제법 법률가분들과의 네트워킹을 강화하는 것입니다. 그리고 뿐만 아니라 국내 국외에 있는 핵심 단체들과의 협력 역시 강화하는 것이 저희의 앞으로의 도전 과제입니다. NK워치 자체적으로도 역량을 당연히 강화할 것입니다. 그중 하나가 일선 현장에서 발생하고 있는 인권 침해 그리고 김정은과의 상관관계, 즉 김정은의 책임 여부에 대해서 명확하게 조사를 하기 위해서 북한의 권력구조 메커니즘에 대한 연구도 진행을 할 것입니다. 그리고 북한 내 정치범 수용소, 현재 운영되고 있는 정치범 수용소와 해체될 정치범 수용소를 포함을 해서 북한 정치범 수용소의 내부와 외부의 폭력적인 구조에 대해서 저희가 알려드리기 위해서 현재 3D 모델링을 통해서 시각화 자료 구축도 준비를 하고 있습니다. 네, 지금까지 NK워치의 과거와 현재 그리고 미래에 대해서 말씀을 드렸습니다. 오늘 경청해 주신 분들께 모두 감사드리고요. 특히 증언자 3분 모두 와주셔서 너무 감사합니다. 제 이야기를 이상으로 마치겠습니다. 감사합니다.
Thank you, Dr. Lee. And now I would ask a leave for the organizers to grant us 5 more minutes, because the presentations by 4 legal researchers in England were planned each for 5 minutes, and not without a reason. because I think some introductory notes before our colleagues in England started their presentations probably will be useful at this moment. We are now at the moment that we are moving the discussion from establishing the facts and collecting data on breaches of human rights in North Korea. And we are now moving from advocacy activities to accountability topic. So second important thing is for all of you to consider is that there is a view that ownership of the process of seeking for accountability should be with those who suffered, with the victims. And how does one achieve this? So there are many NGOs based here in the region in South Korea, but also worldwide, who have been engaged in different sorts of activities in recording North Korean human rights breaches. And one of the issues and one of the important stepping stones would be how to organize cooperation and exchange of information between such NGOs, nationally, regionally, but also how to cooperate on international level, because there are many international NGOs also dealing with this issue, not as a monotopic, but in a plethora of other human rights breaches that they do. Another important issue is obviously intergenerational dialogue. One generation has been offering for quite a long time an experience and wisdom, but new generations are coming in, taking over or engaging in the same sort of topic, but with a different educational and referential background. In the time that we started this job, we did not have master degrees on international criminal law and so forth. In other words, I'm very pleased to introduce 4 young lawyers who do represent this upcoming generation that has actually raised expectations about accountability, just because at this moment we have many more mechanisms and instruments that we had before the end of the Cold War. 1990s actually inaugurated a new world where we at least can try to seek accountability at individual level, but also at the level of state accountability. So it is my a pleasure now to introduce 4 lawyers from England, and they will speak all about part of the topic that they have researched. First of them is Ms. Ruby Peacock. Ruby Peacock, the floor is yours.
안녕하세요. Hello everyone, and thank you to NK Watch for organising this important conference. Next slide, please. NK Watch asked the Geoffrey Nice Foundation to analyse witness statements of victims of the DPRK regime and to compile a report addressing whether a case against the DPRK state or officials or individuals within the regime could be brought through an international mechanism of justice. Next slide, please. To establish whether a case can be brought, there are 2 questions which need to be answered positively or in the affirmative. They're on the screen. Firstly, does the evidence suggest that crimes as defined by international law, such as crimes against humanity or genocide, have been committed? Second, can a legal route be established whereby an international judicial body will have jurisdiction over the alleged crimes? These are the 2 questions our report looked at. In relation to the first question, we concluded that there was strong evidence that crimes against humanity, in particular torture, enforced disappearance, imprisonment, enslavement, rape and murder, have been committed in the DPRK. Furthermore, the statements provided clear evidence of criminal acts which could potentially amount to genocide. However, further evidence is required of the songbun status of each victim in order to prove or disprove that particular argument. In relation to the second question on this PowerPoint slide, we reached three conclusions. First, although the International Criminal Court could prosecute and imprison members of the DPRK regime for crimes against humanity, this would likely be impossible in practice because the DPRK has not signed the Rome Statute. Second, universal jurisdiction could be a viable option for making a political statement, but would require NK Watch to identify a country which operates universal jurisdiction and which also has a sympathetic prosecuting authority and a sympathetic judicial system. Third, and finally, in terms of the conclusions, the International Court of Justice could prosecute DPRK states for genocide, but only if another state were willing to initiate proceedings. I will now explain our conclusion in relation to crimes against humanity in a little more detail. As I noted in my introduction, next slide please, apologies, there was strong evidence that crimes against humanity had occurred. Crimes against humanity are relevant in the context of the DPRK because it appears on the face of the evidence that there was an organised regime which involved state bodies systematically arresting, detaining and treating large numbers of the civilian population in a manner counter to international law. These crimes appeared both systematic and widespread. They appeared widespread because they took place over a large geographical area at various state detention facilities. And they appeared systematic because we noted strong similarities in the acts which were being committed and the way in which they were being committed, regardless of where they occurred within that large geographical area. Finally, the Rome Statute determines that crimes against humanity must be committed in furtherance of a state or organisational policy to commit an attack. We concluded that this can be inferred from the totality of the circumstances, given the widespread and systematic nature of the crimes and the involvement of state bodies in the commission of the crimes. I will now pass over to my co-author, Nathan Fuller, who will address our analysis in relation to genocide.
Thank you, Ruby. Good morning and good afternoon, everybody. Our analysis of the NK Watch witness statements provided clear evidence of criminal acts which we believe could amount to genocide. However, in pursuing this route of legal recourse, we will need to first successfully argue for an expansion of the current definition of a protected group, and second, without the direct and explicit evidence relating to genocidal intent, it would need to be successfully inferred from the relevant facts and evidence. And therefore, we need additional evidence, for example, the songbun status of each victim, to support this argument. Next slide, please. It is these two concepts that are on the screen now that would form the most significant part of any legal pleadings in this case. Next slide, please. Beginning with the expansion of the definition of protected groups, our main conclusion here is that one could argue for an expansion of the current definition to include politicide. And this is due to the existence of the songbun system in the DPRK. And it could be argued that the victims in this case were considered part of a political group. Individuals of low songbun, an artificial distinction placed upon them by the state, face severe restrictions and limitations in society, indicating that they are viewed as a distinct group by the DPRK authorities. Therefore, we concluded that a legal comparison could be made with the artificial classification imposed on the Hutus and the Tutsis in Rwanda. And here, the ICTR recognized that the Hutus and the Tutsis were not technically separate ethnic groups having a common language and culture, but they were a separate ethnic group for the purposes of genocide. And we believe this could be applied to the Songbun system in the DPRK. Turning then to genocidal intent, and the next slide please. As stated, without explicit evidence relating to genocidal intent, it will need to be inferred from the relevant facts and evidence from the witness statements provided. In our analysis of these witness statements, we found evidence such as the high level of logistical support and protocols for the transport and detention and imprisonment and torture of victims, the evidence of systematic killings and the disposal of bodies. Importantly, also, the unitary ideology system of the DPRK, it effectively compels state organizations to treat those who are hostile to the norms of the regime as the enemy. And indeed, the DPRK has deployed considerable resources to ensure the arrest and punishment of Christians and others considered to be introducing subversive influences to society. But the most compelling evidence came from the extreme cruelty of the acts perpetrated by the state. The high level of physical, psychological and sexual violence, abuse and torture, the killings of infants and newborns, the permanent disabling of victims, the fact that victims were subjected to enslaved labor, starvation, deprivation of water, sleep and medical treatment, amongst other horrific crimes. These could all be used to infer genocidal intent. Next slide, please. However, the primary concern, based on the evidence that was provided to us, is that the application of these acts to the victims, on the face of it, does not appear to be uniform, and in some cases seems potentially arbitrary or random, which could negate allegations of genocide. Therefore, further evidence is required of the Songbun status of each victim, as this would support an argument that the actions of the DPRK officials recorded in these statements are not random, but part of a wider system of oppression, punishment, and ultimately genocidal destruction. So to conclude, we believe there is evidence of criminal acts which could amount to genocide, but we would need to successfully argue for an expansion of the current definition of a protected group, and we would need to successfully infer genocidal intent from the relevant facts, and further evidence is required. I'm now going to hand over to my colleague, Adam Smith, who will discuss the litigation options available. Thank you.
Thank you very much. As part of our research, we considered 3 avenues for bringing the DPRK to justice: the International Criminal Court, or ICC, Universal Jurisdiction, and the International Court of Justice. And I'll address these in turn. You already have the core background information of all of these options in the conference programme. Broadly, we conclude that the most effective routes of pursuing the DPRK through litigation are through universal jurisdiction or the International Court of Justice. I shall, however, turn briefly to the ICC and why we concluded that it is not a viable option. The ICC, next slide please, is the world's specialist international criminal court, with the main benefit of that, that a conviction would lead to imprisonment of DPRK leaders. It is also a court that prosecutes crimes against humanity, which, as mentioned, is the most appropriate crime to prosecute the DPRK for. However, there are 3 main issues preventing NK Watch from pursuing this route. First, the ICC generally requires member states to sign up to it for a prosecution to be brought against their citizens. The DPRK has not done this. Next slide, please. Second, if crimes are committed across the border from the DPRK into a state that has signed up to the Rome Statute, then this could lead to a prosecution in the ICC. However, our analysis concludes that this cannot be proven due to insufficient evidence of this happening with the current evidence. Thirdly, whilst a prosecution could be brought through a referral from the UN Security Council, there are concerns over China's ability to use its influence to prevent this. As a result, pursuing a prosecution in the ICC is therefore not viable at present. Next slide, please. These are broadly the benefits and negatives outlined. Next slide, please. Universal jurisdiction, on the other hand, could be a viable option. Universal jurisdiction is the ability of any state in the world to prosecute crimes, such as crimes against humanity and genocide, in their domestic court system. These crimes can be prosecuted provided the state in question has passed laws to allow this to be done in their state. There are again 3 challenges in using this route, but these can be overcome. Next slide, please. First, NK Watch would need to find a country that has legislated to prosecute crimes against humanity and genocide. Several countries have put provisions in place for this to happen, so there is choice in this matter. Second, depending on which country is chosen, it may be necessary to find a prosecuting authority in that state that would be willing to bring a case against the DPRK. Persuading such an authority may be challenging. Alternatively, some countries may allow NK Watch to bring a private prosecution under universal jurisdiction. Thirdly, even if an appropriate country and a willing prosecuting authority were found, NK Watch would still need to find a sympathetic judicial or court system. This is because the matter of prosecuting the DPRK is a highly political issue, given that it concerns both international relations and diplomacy. And some courts have refused to hear cases like this in the past on this basis. The benefits, however, should these hurdles be overcome, are significant. Depending on the country, Kim Jong-un could be prosecuted for crimes against humanity. If he came to that country, he could be arrested or imprisoned. Even if he did not enter that country, the recognition by a national court system would send a significant political message to the DPRK and add pressure to make changes. I will now hand over to my co-author, Holly, to discuss the final route, the International Court of Justice. Next slide, please.
Good morning and good afternoon, everyone. So pursuing North Korea, the DPRK, in the International Court of Justice would not be a prosecution as in the International Criminal Court, but instead state-to-state litigation between UN member states. Another state could bring a case against the DPRK at the ICJ if they are both signatories to the same treaty, and it is a treaty which gives jurisdiction on the ICJ. Jurisdiction is the power to make judgments on this case. If a dispute of the kind envisaged in a clause of a treaty arises between the states who have signed it, they may bring the matter to the ICJ. To pursue a claim here, there is no need to find another state signatory to the same treaty as the DPRK, which also falls under the ICJ's jurisdiction. The DPRK, having ratified the Genocide Convention, can be brought here for acts of genocide. Next slide, please. We can use the case of the Gambia and Myanmar, a recent case brought to the ICJ for genocide. Here, the Gambia asked the court to intervene and enforce the Genocide Convention. As both Myanmar and the Gambia signed the Genocide Convention, which falls under the court's jurisdiction, countries that have signed the Genocide Convention can bring other states to this court despite having no connection to the alleged crimes. The ICJ has in fact provided provisional measures in January earlier this year to Myanmar. Provisional measures are injunctions or interim orders, which are requested when one state believes that there is an ongoing legal violation from which it will continue to suffer some harm while the court considers the underlying claims. Next slide, please. As you can see here, we have a brief outline of the demerits and merits of this option. Firstly, turning to the demerits. Countries cannot be forced to submit to the ICJ, and countries must consent to its jurisdiction. that the court has no power to deal with applications from individuals, non-governmental organizations, corporations, or any other private entity. Secondly, it is highly likely that the DPRK will publicly reject the authority of international organizations such as the ICJ, as it has done in the past. And the question remains as to whether the government would comply with the court's orders and decisions. In the case of Myanmar, they explicitly recognize the ICJ's authority. However, there is no guarantee that this will happen here. Further to this, there may be a violation of provisional measures. As in the Myanmar case, a state found liable in the ICJ may still reject the findings of the court and refuse to implement them. They may not even show up to the proceedings. And this becomes difficult as the final demerit, as there is no way for the ICJ to enforce its decisions. And briefly turning to the positives, a state in this case can take action without being directly affected, as was the case for the Gambia. Further to this, a state can file a request for provisional measures, as I mentioned earlier, which have a binding effect for the parties to dispute before the court. Further to this, the DPRK has signed a convention, meaning there is no limitation on bringing them to the ICJ in the future. And finally, the argument on genocide has not been recorded before, and this would vastly raise awareness for the cause of the DPRK's victims. I'll now hand back over to Nena.
Thank you very much, Polly. Thank you very much, Adam, Nathan, and Ruby. We have now reached the break, and I shall turn to our host to ask how shall we amend the schedule, because break was scheduled for 15 minutes, but I think we need rescheduling. We shall reconvene this meeting in 10 minutes time, 10 minutes past 2 o'clock. Thank you very much for your attention, and see you in 10 minutes.
Okay, we will now have a 10 minutes break. Please kindly understand we are not allowed to have coffee or snack due to social distancing policy. Thank you for your understanding.